Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk today not about firearms, but instead about knives. Ooh, why is that? Well, we're going to talk about switchblade knives because that seems to be a hot button issue in the courts right now. Now, there are some who believe that perhaps these instruments aren't even protected by the Second Amendment. Of course they are. We got two cases that are happening in real time. They came to diametrically different rulings, and they did so because, well, it's the inclusion of just one or two words that will give these courts the hook that they need to hang their hat on. So today, we're going to use these cases to really prove the point of just how important this is and why we need to pay attention to this area as well. So today, let's geek out for a few minutes and let's talk about the two switchblade cases, which show how critical this fight is. Okay, and today's video is brought to us yeah, right. Okay, so hey, listen, before we get going too far down the road we're going down, I'm proud to announce that this video is being brought to you by, but don't tell anybody, Taylor Freelance. Now, we would love to show you all the cool things that Taylor Freelance is making right here in the United States of America. That's right, because they're based right there in Bellingham, Washington. But here's the deal. If I start showing you all the cool stuff they're making, well, then Google and YouTube, they're going to kind of crap their pants. Let me just say it this way, though. They don't make firearms, got that, Google? But they will make your firearms a lot better. So whether you're looking for base plates, brass back straps, or any other component to make your firearm better fit for your use, well, then you need to go visit my good friends at Taylor Freelance. Now, normally I'd just go ahead and run the little link right down below, but yeah, you see, Google get a little pissed about that too. So instead, that's a link to our partner page right there. You can go there and then you can find the good folks at Taylor Freelance and check out all the cool stuff that they're making, because you know it's cool if YouTube doesn't want it here. Okay, America, this is what we're talking about today. Does the Second Amendment protect switchblade knives? Because that is the issue before two cases, one in California, one in Massachusetts, that got the rulings diametrically opposed. Now, a couple of lessons that we can learn from these cases. The first is even though you may not be into knives, I think you need to pay very careful attention to this area of litigation, because you got to remember, if they make inroads as it relates to knives, we're still talking about the Second Amendment. They will be making inroads into all bearable arms. The second reason is I'm going to give you an example of how you just change one or two words in a rule of law and you're going to be able to hang your hat on a completely and radically different legal conclusion, as was the case here. The two cases we're talking about today is Knife Rights v. Bonta. We all know what state that came from. That's right, that is in California. And then Commonwealth versus Conjura. That is a case from Massachusetts. Now, here's the thing. One of these courts has ruled that the Second Amendment has no application whatsoever to switchblade knives. That was in California. The other court, Massachusetts, actually said, nope, they are in fact protected by the Second Amendment. And since the government cannot justify the ban with a historical analog, that ban is actually unconstitutional. How can two courts on opposite sides of the country, but examining the exact same rule of law and basically the exact same facts, come to such a diametrically opposed decision? Well, it's really simple. You see, in California, what the district court decided to use there was to use the test of in common use for self-defense. And I know you're sitting there going, I'm not familiar with that test. Yeah, I'm not familiar with that test either, but there have been many, many opinions which have bastardized the holdings of Heller to say that in common use actually means in common use for self-defense. Now, we also know under the common use test that the only types of historical analogs that exist for banning firearms are for arms which are deemed to be dangerous and unusual. But what the court has done here is they believe that the test is to be dangerous or unusual. And of course, all weapons are going to be dangerous by design, which means theoretically, with that rule of law, could not all weapons then be banned? The court in California specifically ruled, second, the courts must determine whether the regulated switchblades at issue is commonly used for self-defense. Because plaintiffs bear the burden of satisfying Bruin Step 1 and fail to prove that the regulated switchblades are in common use today for self-defense, or that the weapons are not dangerous and unusual, it follows there is no genuine dispute of material fact as to this issue, And for that reason, he has granted summary judgment to the state of California. California's switchblade ban remains into effect. How did he do this? The judge did it by simply saying that it's in common use for self-defense. So the numerical value, the 1.2 million switchblade knives, which are sold annually, means nothing to that court, okay? Now, when we take a look at the Commonwealth case, Commonwealth v. Conjura, we see here where the court actually applies the correct rule of law, because they do analyze this under the common use test. Not the common use for self-defense, the common use test, which means the numerical value of how many of these items are in circulation is critical to that inquiry. And it's selling at 1.2 million per year. The court had no problem finding that these were, in fact, in common use. That is the correct inquiry, and that is the appropriate end of that inquiry. The court also said that the test is dangerous and unusual, not dangerous or unusual. So, the removal of for self-defense in the first part of the test and switching from and or is exactly how these courts could literally reach diametrically opposed decisions. Now, you got to remember, the court in Commonwealth v. Conjura would have said that the Second Amendment does, in fact, protect these arms, and then so therefore the government must have had to proffer some type of historical analog to justify this sort of regulation, which the government clearly did. And we know which one they're going to use on switchblade knives, because if they use it on high-capacity magazines and assault weapons, you know the Bowie knife is going to be at least a little bit closer in similarity to that of the switchblade knife. However, the court in Massachusetts was not convinced. No, they said, hey, you're talking about a fixed blade knife. This is not a fixed blade knife. It is apples to oranges. It is not relevantly similar, and therefore you have proffered no appropriate historical analogs. And the court has found that the Massachusetts switchblade ban is in fact unconstitutional. So America, why do we need to watch these cases? Well, we need to watch these cases because while we sit there and we look at the assault weapon ban cases, and we look at the pre-purchasing licensing cases and the high-capacity magazine ban cases, unbeknownst to us, our Second Amendment is under attack from all fronts, including through other instruments other than firearms. And remember, if those who advance the cause of civilian disarmament make advancements in the world of knives, that rule of law would apply equally to your firearms. And that is the big reason why all of us need to pay very careful attention to these cases. Listen, we're going to go ahead and link up both the California and Massachusetts case down below so that you can geek out on it for yourself. Maybe you got some questions about this or something else related to what's left of our Second Amendment rights. You guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. Maybe you got an idea for a video we should be doing around here. If you do, go ahead and click on that link right there. A lot of the good ideas we have around here are not our ideas at all. Maybe you just want to subscribe to our monthly newsletter. The ability to do that is all down there in the description box. And then finally, and most importantly, America, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.